Hello, and welcome to another episode of Trust and Trade, a podcast produced by the Antitrust Law section of the American Bar Association. Trust and Trade is a podcast for seasoned practitioners interested in deep dives into the areas of competition, consumer protection, and privacy law, and casual listeners who want to better understand some of the hot-button issues in these fields. Each episode is presented by one of the specialty committees within the section. This episode is produced and co-hosted by the Mergers and Acquisitions Committee of the Antitrust Law section, and as part of our ongoing Mergernomics series that explains the tools, tests, and analyses commonly used by antitrust economists in merger analysis. Today's episode is on extending market power in tech mergers. In ordinary terms, before we get to the more technical analysis, the question we're talking about today is when it becomes problematic for a dominant firm to extend its market power by buying a company in another market. It's not always a bad thing. If the dominant firm retained its market power because it was more innovative or had a better cost structure or superior management, maybe you're better off when a company like that brings those capabilities into a new market. On the other hand, a firm acquiring a company in another market could negatively impact competition if the company it's acquiring provides a critical input, like training data for the AI market, or medical technology in the medical device market, or movies, televisions, and videos for the streaming market. More recently, we've seen enforcers and policymakers around the world express concern over investment stakes being taken by dominant firms like NVIDIA, Microsoft, Google, and Meta in upstart AI companies, fearing that these firms are buying out startups that could potentially turn into their competitors. To help us understand just how to think about dominant firms extending market power are my guests, Elizabeth Wang and Daniel Culley. Elizabeth Wang is an economist at Econic Partners and heads the firm's China practice. She has more than 25 years of experience providing economic analyses and merger reviews, commercial disputes, and regulatory hearings. Daniel Culley is a partner at the law firm Cleary, Gottlieb, Steen, and Hamilton LLP. His practice includes counseling, merger control, antitrust litigation, and government investigations, particularly for high-tech industries and two-sided markets. Welcome, Dan and Elizabeth.
Thanks for having me, Anant.
Glad to be here.
Dan, why don't you start us off by telling us a little bit about what we mean when we're talking about market power?
Yeah, and I'm actually going to turn that around and frame it as a question for Elizabeth, because I think she could help us think through this a little bit from an economic perspective. So, Elizabeth, when we talk about extending market power and think about how a merger can actually do that, how do you think about that as a broad topic as an economist?
So Dan, that's a really good question. When a merger allows the merged firm to extend its market power from one market to another by harming its competitor, that can be a problem. So suppose a company just recently acquired a new product line through a merger, and now it has two different products, and one is strong, one is weak. It can be very tempting for the company to try to use the stronger product to help the weaker product. And when a firm is dominant, and when this dominant firm in that one market using a full closing strategy to help the weaker product, that at that time, harm to competition may occur. And there are many different ways for a company with dominant position to use one strong product to help the weak product without harming competition. For example, the merged company can have a one-stop shop to allow customer to buy both products easier. Or it can create a bundle, only allow the two products to buy together. Another example is that the merged company can create better design to allow products it required to work together better, or it can harm a competitor by only allow its product to work the best and the other product doesn't work at all. So the concern of extending market power in mergers is likely to rise in vertical mergers and conglomerate mergers. And let me start by saying there are three types of mergers in general. A horizontal merger usually combines companies within the same product markets. So there's no extension from one market to another. The second category of mergers is a vertical merger, where the merger combines companies in the same supply chain, one in downstream, one in upstream. So it is possible the merged firm can extend its market power from downstream to upstream, which is we call customer foreclosure, or from upstream to downstream, which can be called an input foreclosure. The third category of merger is conglomerate merger, where the companies are operating in two complementary product markets. And in that situation, for example, the merged party can provide their complementary products into a bundle where a competitor only produce one of those bundles cannot effectively compete. So all in all, let me emphasize that vertical mergers and conglomerate mergers many times can create efficiencies. And therefore, it is very important to do case-specific analysis to evaluate where this vertical mergers or conglomerate mergers actually is creating efficiency that's large enough to offset the harming competition part, or it's the other way around. So let me pause here. Dan, let me come back to you. You have handled a lot of vertical and conglomerate mergers. Can you give us some examples in real cases? What are the specific mechanisms that companies, mergers, allow market power extension that happened?
Sure, Elizabeth. And to be clear, I'm going to stick to what the agencies alleged in these cases. Obviously, there were in the actual litigated cases, there were a lot of different views on both sides. But one classic one was the AT&T Time Warner transaction. So there, the DOJ had alleged that AT&T was either a monopolist or a duopolist in most of its cable service areas. And after acquiring Time Warner's programming, the AT&T's cable division would have an incentive to drive a harder bargain for programming that was rivaling Time Warner's. And so, there we would call that customer foreclosure, and that'd be an example of that. On the input foreclosure side, you could think about what the FTC alleged in Illumina Grail. There, they alleged that Illumina was a monopolist for short-read next-generation sequencing machines, and that it was acquiring a larger stake in Grail, who made the only cancer test close to commercialization that ran on top of those machines. And the FTC essentially said the acquisition would give Illumina the incentive to deny access to the sequencers or delay the shipments or raise the price or limit access of consumables for tests that might come to market in the future to compete with the Grail test. So those are examples of, I think, the relatively classic input and customer foreclosure mechanisms that you just described in actual cases brought by the agencies. Why don't we talk about how you would think about a framework for doing the kind of case-specific analysis that you just mentioned a little bit earlier? I know we both worked on the Broadcom VMware transaction, which was a conglomerate merger. So maybe you could use that as a template as well.
Dan, that VMware Broadcom merger we worked together is a really good example to explain how economists can analyze market extension and what's the general framework. So let me take one step back. The general framework for analyzing foreclosure impact usually have three elements: incentive, ability, and effects. So if there is a dominant firm post-merger want to engage a strategy to foreclose competitors, it need to have ability to do it. It also need to have the incentive for doing such a thing. And third, even if it has incentive and ability, the impact of such strategy need to be big enough to harm competition in the market. So Broadcom VMware merger is such a conglomerate merger where some of the regulators raise that concern. So let me start by explaining the products in that merger. Broadcom's main product in that merger was connectivity cards for data centers. VMware's main product are virtualization software for data centers. Let me use our company's data center to explain their products. So when I go into Econic Partners data center, it's a big room with shelves and shelves of black box, blinking lights. And those black box, they're servers. And these servers are connected with wires and cards. Those wires and cards are connectivity cards. Let me use that shorthand to explain. And that's what Broadcom is making. And all those servers are connected together to create a cloud of space. And where one part was assigned to me to allow me to store my case materials. So those are the virtual space that was assigned to me. This virtual space was made available through virtualization software, such as VMware's products. So now we see it's the virtualization software and connectivity cards that the parties was producing but used in the data center like ours. In that matter, the regulators specifically concerned about post-transaction, the merged firm might extend its market power in virtualization software market into the connectivity cards market. Specifically, the mechanism it worries was that the merged firm may make this VMware's virtualization software incompatible with other rivals' connectivity cards. In order to analyze this kind of foreclosure strategy, we did a number of analysis for ability. For example, we analyzed the overlapping customers between VMware and Broadcom. In order for incompatibility to work, it means that data center customers need both connectivity cards and virtualization software. What we find out was that a lot customers, they only need bare metal in the sense that their servers, the black boxes, they're connected together, but they're not virtualized. So that means those customers does not need virtualization software, and the merged party will have limited ways to exercise the incompatibility strategy with using the VMware software. So for incentive analysis, we asked the question, would it be more profitable for the merged firm to make the VMware virtualization software incompatible with other people's connectivity cards? Knowing that many of the data center customers may be upset and switch to competitor virtualization software such as Microsoft Azure. Or would it be more profitable to keep that software compatible to all different brands of connectivity cards? What we find out was that under a large majority of cases, incompatible strategies would just lead to less profits. So let me pause here for a minute. And Dan, it is my personal view that the most powerful analysis that make that transaction went through was the analysis on effects. And when you present our analysis, both our advisor as a group to the European regulators, it was so effective. Could you share your explanation on that?
Absolutely. So, I think it's actually a really great example because it shows that, we're talking about relatively classic theories in terms of foreclosure in either direction. One of the things that makes tech case is different is that the details of the technology really matter a lot. So one of the things that you mentioned was that the European Commission alleged that Broadcom had a dominant position in the input-output cards for a specialized storage protocol called Fiber Channel, and that to use hardware like this with VMware's virtualization product, VMware had to certify it. And so the theory was VMware would delay certifying Broadcom rivals' hardware. And I mean, just to be clear, we disputed every level of that, right? So we disputed the product being dominant. We disputed that VMware had any incentive to do this, especially since much of the value of its product was helping companies standardize data centers across very different types of hardware. But your question was focused on what we did to demonstrate, even if the dominance were true, even if the incentive were there, what would the effect be? And so, we did think about what would happen if they did foreclose and it was 100% effective, which is, it's really never going to be in life. But just to ask that question to see what kind of scale that we're dealing with. And so, again, well, it felt like a typical input foreclosure theory in the sense that, the rivals need the certification. That's an input to what they sell. On the other hand, it's not something that was really being sold. It was just an action that needed to be performed out on the market. And another unique technical feature of certification is that it's all or nothing. I can't certify a rival's product halfway. It's not something that exists. Either I certify it and the driver works with my software, or I don't. That's not a feature that we often have in, a traditional physical good market. For example, I could maybe deliver something more slowly or more quickly. So that was another unique piece of that. And then finally, we had the issue of backwards compatibility. And, so once we had a product that's out there in a data center that's already running, it really was not a tenable strategy to revoke the certification for that product. If you could think of a data center that's out there, running a company's email servers or doing something like that, and you literally took an action that completely shut down their existing operating data center, I mean, everyone in the case, even the complainants, I think agreed that if VMware had done something like that, it would just be catastrophic. There would be a mass exodus of customers from the product, and it just wasn't a tenable strategy. So, that was good because then we had at least a common factual basis to move on. So, what we did then is we took each of these facts about how the market worked and we put them together. And then we actually looked at, what the adoption rate was for the brand new products, the ones that aren't actually in a data center yet, where maybe you could argue that, you'll hold back the certification, you won't do it right away, which was the European Commission's theory. And, it turns out that the adoption rate for these really frontier products was quite slow. And so when we calculated that out, we were looking at, really trivial amounts of money, even if the foreclosure was 100% successful. So for one of the products, it was literally a couple $1,000s. For this product, it was definitely below $100,000. And so, what we were then able to say is, look, we're literally at the level of financial gain where you would actually ask the question, is it even administratively worth it to spend an employee's time doing this? But also, it's the kind of thing that could be canceled out by even really trivial changes to the reputation of a product or something along those lines. And, I think ultimately that is the kind of argument that drove us to unconditional clearance in the US and to, what we view as a relatively favorable remedy in Europe. So moving away from conglomerate mergers to vertical mergers, do you want to talk a little bit, Elizabeth, about the key economic tools for analyzing vertical mergers?
Yes. Before we go into analyzing market power extension in vertical mergers, I want to make sure we understand there are efficiency gain embedded in vertical mergers. So let me start there and explain that. Consider the following example. A API provider, which is the upstream, is making a very specialized AI model that can have a super accurate image recognition tool. And it's a great product, and it's been sold, it sells to app developers at a generous price. So that's our first profit markup. And now there is an app developer for a social media app that used this API tool for image recognition. And its social media app is quite successful. And this social media app has a subscription fee that taking into account the API from the image recognition and other costs. And there we have our second price markup. Consider these two companies merged together, one upstream API, one downstream social media app. And now this merged company considered all the costs together and set a new price for the social media app. And there is only a single profit markup. As a result, the social media app price would go down, total demand would go up, and total profit would go up. So this is a single profit markup under a vertical merger that reduced the two-step markup when they were operating separately. So this is called elimination of double marginalization. Many times you will hear EDM.
Dr. Wang, just to clarify for the listeners, if that API was critical to a number of other app developers, you'd have to weigh that against possible foreclosure of other app developers. Is that right?
Absolutely, Anant. So that is where I'm getting at. For a vertical merger, it's possible that some of the foreclosure would happen. Dan mentioned, and I mentioned earlier, input foreclosure, customer foreclosure. And with that in mind, we also need to think there's efficiency gain that embedded for many of the vertical mergers. So now we move on to the market extension element of a vertical merger. It can happen. As we discussed earlier, when a party is dominant in one of the two, either upstream or downstream, it can use that dominant position to extend it into the other market. So let's use the example of input foreclosure, where the merged firm is really dominant in the input market. And it can use that dominance position in a harmful way to exclude or harm competitors in the downstream, which is the social media app market. So that's there are two main mechanisms, even under this input foreclosure strategy. So let's look at let me start with the number one. That's called full foreclosure. In that example, that API company can stop selling its API tools for image recognition to any other social media apps. There, the question is this foreclosure big? It's possible, just like the three steps we mentioned earlier: incentive, ability, and effects. And there is a very common economic tools to analyze that. It's called vertical arithmetic. So it's similar to the Broadcom VMware case we mentioned earlier. The question is, there is a trade-off between lost profit from not selling to downstream other social media apps. So that's a lost profit on upstream. And then there is a gain from potential more subscriber for social media app in the downstream. So the vertical arithmetic help us to assess this trade-off And that's the incentive analysis we can do here. However, the foreclosure strategy does not need to be full foreclosure. There is another category we call the partial foreclosure, in the sense that the API company is still selling its tool to other social media apps, but with a higher price. So in this way, it aims to rising rivals cost to give its own social media app advantage. And we have a commonly used economic tools to analyze as well. It's called VGUPPy. It is quantify the upward pricing pressure for the merged party to increase the input price, and to what extent it can harm the rival social media app, and to what extent the incentives there. So those are the typical economic tools to help us thinking through economic analysis on whether foreclosure strategy is effective, have ability, have incentive, and effective in the vertical merger. Now, let me go to you, Dan. I understand you were deeply involved in a recent vertical merger. Temporarily merged with mattress firm. And FTC have raised concerns that this merged firm would extend its market power from mattress retailing market into the mattress making market. What was FTC's key theory of harm and their key evidence?
Sure. And I know we've largely been talking about tech cases, so people may wonder why we're taking a detour into mattresses. Although they are very technically sophisticated. I learned a lot about that.
As someone who just went mattress shopping for the house, I'm dying to hear this whole story.
Well, I think you have to buy a temper ceiling mattress. That's all. That's the only thing I'm ever going to recommend. But I actually think it's a very interesting market because it does share a lot of features, some of the technology markets. And it's a market where manufacturers set the price directly, which is something that we see on a lot of tech platforms. There's multi-homing across many different retailers, which is another feature that we see in tech transactions as well. So, even though it's a much more physical good, physical retail, I think some of the economic principles do track across a number of these. And, just to dive in a little bit, what the FTC had alleged was that Tempur Sealy had a very strong position already in premium mattresses above $2,000. There are a lot of problems with that market definition. I'm going to skip over that a little bit to focus on some of the other issues. But the FTC alleged that once Tempur Sealy controlled Mattress Firm, it would kick Serta Simmons, Purple, and anybody else out of Mattress Firm, which would reduce those other manufacturers' competitiveness. So that was the basic theory. You're going to buy it, you're going to kick them out. And the key evidence that the FTC was putting forward on each of these points was, let me put it in kind of the ability, incentive, and fact that you talked about before. On ability, they were saying, look, nobody disputes that the mattress stores can pick what products they sell. They don't have some kind of legal obligation to stock a particular thing. So, at least there's the technical ability to do it. On incentive, the FTC had some colorful documents where pre-merger, in the ordinary course of business, some executives were talking about, hey, let's get into this retailer and kick the competitor out. That's what the FTC focused on for incentive. And then on effect, there was some qualitative testimony from Serta Simmons that it would suffer some grievous harm if it were not able to distribute through Mattress Firm. And there's some more equivocal testimony about the same from Purple. And that's primarily the qualitative evidence that the FTC put forward about effects. And then the FTC economist also introduced a model that tried to quantitatively assess was there incentive and what would the effect of doing this be. So that was also in the mix.
So how did you size up their argument and positions?
Well, we thought there were a number of issues, but a few of those stood out to me. So I think with respect to the colorful documents, those are really all about the company's incentive before the merger. But a manufacturer that doesn't own a retailer, of course it would like its rivals to be kicked out of retailers. We actually should be a little worried if it wasn't trying to do that. So we didn't think they were that informative, right? And that's something we certainly pointed out to the court. And then on effects, one of the most interesting things was that FTC chose not to put forward a market share for Mattress Firm. And that's something they would say they don't need to do for the product being withheld under their merger guidelines. I guess that's what they say. But if you kick a rival out of a retailer that has like a 1% share, I think hopefully everybody could agree that that's probably not going to have much of an effect. And then it turned out when we actually were able to get discovery and find out, the size of our competitors and who is distributing through where, the Mattress Firm had a share under 30% in this segment that the FTC was trying to define. And, about 2/3 of its floor space was already Tempur Sealy mattresses. So the amount of market-wide floor space we were talking about potentially taking away is really materially under 10%. And so that was kind of a red flag for us that the effects case probably wasn't there. And then when we looked at the FTC economist model, there were just things that when we unpacked what was actually going on inside of it seemed a little bit fishy. So he was saying that Tempur Sealy would kick its rivals out of Mattress Firm entirely. And certainly, given the documents that they had, I understand why that was narratively compelling. But I think most economists would agree that it's actually pretty rare that you would want to stop dealing with a rival after a vertical merger. It's almost always more profitable to renegotiate with the rival and deal with them at a higher price. And so the fact that the model didn't allow for that to happen was a bit of a red flag. It just turned out it made that process impossible. So we fixed that. And unsurprisingly, when we went ahead and did that, it turned out that renegotiation was the most profitable thing to do, not actually kicking them out. The other thing that we noticed was when the renegotiation happened, so prices did go up in his model, but so did the rival's profits, which was very strange. His model was literally saying Serta Simmons was actually better off, even though it's paying a higher commission to Mattress Firm, and because of the prices in the market going up. But, that's pretty hard to square with a very impassioned person from that company on the stand saying how the merger was going to ruin their life. So, there's a bit of a tension there in terms of what the government's economic evidence was saying and what the witnesses they were putting up.
Dan, can I ask you just to tie that back a little bit? So Dr. Wang said that when you look at vertical foreclosure, there's the full foreclosure or there is raising rivals' costs and the VGUPI analysis. And so are you saying that when you looked at the potential for just raising rivals' costs, you also found an increase in profit that kind of negated that argument?
Yeah. And, and it didn't negate the argument, which was something that was very bizarre, right? And so it suggested there was an incentive to foreclose, but once the foreclosure happened, the rivals were actually still better off. It was like, that's interesting. It's not like it's theoretically possible, I guess, for it to happen because, when you do sell a rival's product, you make a little money when their product is sold. So it can be like partial ownership. It's theoretically possible for that to happen. But it's pretty unusual to see that in a litigated case, especially one where the rivals are saying it's going to destroy their business. So that really was a flag that came up. And so when we dug into that, what we found was there were two really strong assumptions about how competition worked. One was that wholesale prices were a percentage of retail prices and it never changed. So that this was just something fixed for all time. And then two, even though the FTC was saying, for example, in their opening statement, that one of the ways harm could occur is by a mattress store steering customers from one mattress to another. This is kind of another parallel I can draw to some of the tech cases, these steering concerns. So that's what the FTC was saying, but the model actually had the retailer making no choices at all about what it sold or how much it sold. So this whole dynamic of steering that was getting a lot of airtime qualitatively with the fact witnesses, it just was not a feature at all in the model. And so the result was, the result at the end of the day, both of these were false assumptions. And if you broke either one of them, the results of the model flipped, and it actually showed that the merger was pro-competitive. So, why was that? What was going on that caused that? And to just tie it back to the discussion of eliminating double marginalization that Elizabeth had at the beginning, those two assumptions together were basically wiping out the elimination of double marginalization. They were creating a world where that had already happened before the merger, without a merger. So the first one about the wholesale prices being a percentage of the retail prices that never changed, that's basically like assuming you're already in the joint venture where you share profits between the two. So unsurprisingly, if you're assuming that the companies are basically already merged, you're going to see less benefits from a merger. So that's not surprising. The second assumption about steering is because the retailer had in that model no way to capitalize on the benefit of a manufacturer setting a lower price to it. Like there's no change in behavior that it could do. For example, if it got a lower price from a manufacturer to sell more, to push its distribution resources towards that manufacturer's, in terms of stocking more of its product, giving it more floor space, offering better financing terms to customers for that particular model. So the normal boost that we would get in a vertical merger where the retailer now says, hey, I own this product. And if I sell more of it, I now not only make my commission, I make the margin at the manufacturing level too. So I'm going to work harder to sell it. That wasn't happening because there's no action the retailer could take in the model. So that was kind of another form of eliminating double marginalization. It had just been wiped out. And so if you take either of those away, that came flooding back into the model and it swamped any anti-competitive effects. So that's one way we attack that.
Dan, Elizabeth, this has been a really illuminating discussion. And one of the things that you were talking about earlier, the ability, incentive, effects analysis for these types of mergers. I led off in the opening talking about how enforcers around the world are looking at incentives of dominant firms investing in the AI space. And Dan, one thing that you said that's really jumped out at me is in talking about some of these earlier cases, you talked about how you have challenged every element of some of the enforcers' assumptions, the market share of the firm, its incentives and its effects. And this idea of multi-homing that a number of economists have pointed out in terms of consumer AI adoption, this idea of multi-homing seems to me to be a pretty necessary element of analysis when you're looking at how critical an input is or how critical a market is, because it goes to lock-in, right? And if you don't have lock-in, that seems to be a pretty solid argument against some of the assumptions of acquiring one firm in another market and creating dominance. I don't know whether either of you have any thoughts about that or any response to that.
Yeah, I think it part of it just depends on what the source of the entry barriers are. But, certainly when you're talking about a critical input being, say, distribution, the fact that customers are visiting multiple distribution points, which in a tech context, in the web context, could be websites, web entry points, then that suggests that you can get to that same consumer through multiple different routes. Does that make harm impossible? No, but it means you need to really think carefully through what are you actually denying the rival when they can't go through one particular distribution channel, and you need to follow who or what they were reaching through that distribution channel and what's going to happen when it's no longer available. And so if you think about a case, for example, where the distributor is relatively weak, the preference for the distributor is relatively weak relative to the preference for the product or the service that's getting distributed, it may not matter at all, right? So the person may say, well, what I wanted isn't available there, so I'm just going to go somewhere else. Now, of course, you can come up with scenarios where it's the opposite and the preference for the distributor is super strong. But the customer doesn't have a lot of preference for the service that's presented to them once they're there, or they don't know that it's happening, and maybe you have the reverse. And so but in that case, you would expect not to see very much multi-homing. And so, those are just part of the things that you just really need to think through the details of. And then, reflect them in all of the evidence, what you're bringing out from the business leaders, the fact witnesses, we would call them, as well as, in any economic modeling that you're doing. It has to match the facts that you're putting forward.
Yeah, that multi-homing is indeed one of a common character in tech space. I think it can affect economic analysis for foreclosure in several areas. So for example, when customer multi-homing, that means the switching costs are going to be pretty low because there's many different choices, even though you currently use primary one, but it's the fact you have another there. If a foreclosure strategy is implemented, then customer already have an alternative. It can go easily. That also means the diversion ratio would be high because multi-homing is there. Even if the customer prefer a certain solution right now, virtualization software, even if it's VMware software right now, but because there's Microsoft Azure is available, and many times it probably already have a small public cloud solution out there the customers are using. So the incompatibility strategies regulator was thinking may have a bigger, may less likely to have an impact because customer can easily switch and divert to an alternative. So come back to our economic analysis. It is a very fact-specific, detail-driven analysis. We cannot assume there are certain things going to happen. We do need to go down into the weeds, collect all the data, and make sure we understand its technical specificity as well as the data specificity for that specific merger.
We like to end these episodes with a few takeaways for practitioners. And so let me start by asking Dr. Wang, any key takeaways here on this topic for our listeners?
So come back to the thing I just mentioned. Many of the vertical mergers, conglomerate mergers, they have a lot of efficiency features, and extension of market power is also possible. So we need to assess the trade-off, which one is bigger, and that is very data and fact specific. That's really go down into that route, understand the case, understand the data to make a sensible analysis and sensible model for that merger.
And Dan?
Yeah, I think it's probably the devil is in the details. Vertical and conglomerate mergers can certainly cause harm. It's something that can happen, but you really have to get into the weeds, as Elizabeth said. In horizontal mergers, we have this thing where we know the harm is going to go and you have less competition to some degree when you're eliminating a competitor. And then if you have entry or efficiencies, it's going to pull you in the other direction. It's easier to get your head around that. In vertical and conglomerate mergers, we're talking about complementary products. And actually, just the very same actions that we might be concerned about, like favoring your own product, that could be good or bad. And it's just not a complexity that we deal with in the horizontal case. So, there aren't any shortcuts, and you got to get deep into the facts. And if you want to master these cases, you got to be a master of the factual record.
Well, Dr. Elizabeth Wang, Daniel Culley, thank you so much. I really enjoyed this discussion. It's a very complex topic. How do you quantify the analysis when it comes to these types of mergers and acquisitions? But I found it just fascinating listening to the specific cases and how you think about these things. To our listeners, if you're interested in learning more about some of the topics that were covered in this episode, please be sure to check out some of the other episodes in our Mergernomics series, particularly number 35, which is about guppies, and number 37, which is about vertical math. To our listeners, be sure to subscribe on your podcast platform of choice, and we'll see you next time on Trust and Trade.